Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. We all know that while to decide the civil matters, it takes a lot of time. Normally, generations will go. Of course, if one person dies, if the plaintiff dies, his legal heir can step into his shoes. But I am telling you one case where a person who lived for 108 years and has continued the litigation for 53 years, when the matter was accepted or when the Supreme Court consented to take up his matter in the appeal, he died. A man of 108 years dies pending litigation for 53 years. So, this is the clear-cut situation of the judiciary. Of course, we can't blame anybody because everybody takes his own time. There are certain, if you go through the entire thing, then you have to admit nobody is at fault in this particular case. But such cases do happen. So 53 years of long pending trial, ultimately when the case is accepted by the Supreme Court, the person who averred for the same is not available. He died in the year 2019. Right. Now, his name is Sopan Narsing Gaekwad. Sopan Narsing Gaekwad. He is from Latur area of Maharashtra state. Right. The details of the case are as follows. Mr. Gaekwad, he bought a land in 1968. Of course, the registered sale deed was there, first sale agreement was there, then registered sale deed was also there. So, he was cultivating the land. But those were the days where the original owner cheated a bank. Actually, he has taken the original documents and mortgaged the same with a bank and took some loan. He could not repay the loan. He became a defaulter. The bank people went for, they filed a civil suit and they sent a notice to this man, to this Gaekwad. Gaekwad said, already I have got it under registered title deed. You are cheated. You are cheated by the original owner. So you have to go against him. I cannot against my landed property. Immediately he has filed a civil suit before the court and ultimately the court agreed, the lower court agreed with his argument that he was cheated and therefore the bank people can go for auctioning the land the other land belonging to the original owner. But this judgment has come on 10/9/1982. It has come on 10/9/1982. The court agreed Gaekwad's argument and ruled it in his favor on 10/9/82. But of course, the other people they don't agree. They have filed, the bank people, they have filed appeal in 1987. Right? So, but the first appeal, it went against Gaekwad in the year 1987 itself. Then, you may be knowing, in CPC there is a chance for second appeal when there is a substantial question of law. So, in 1988, he filed the second appeal before the Honorable High Court of Maharashtra. But it has taken long years. 2015, that means almost 17 years. In 2015, the High Court after 27 years, the Honorable High Court of Maharashtra dismissed his appeal and it has given the judgment in favor of the bank. The main contention is this. Okay, when the sale agreement when the sale deed was executed, what is the necessity for him to give the original documents to the original owner? Of course, because he is a gullible right agriculturist, he did not take care of the original documents. That's the main problem. Right, anyway. Now, in 2015, this was dismissed. Then he approached the Supreme Court. Of course, there was a delay. There was a delay of 14-17 days. That means almost 4 years. For 4 years delay was there. because he is a man from rural area. To approach the Supreme Court is also very difficult. But anyway, he has filed an SLP or appeal in the Supreme Court. And the matter has come for decision in 2019, whether to take up the matter or not. In 2019, Justice D.Y. Chandrachud and Rishikesh Rai, they have condoned the delay of 1467 days of delay in filing the appeal, because there is an error apparently on the point of judgment given by the High Court on 23/10/2015. 2015 judgment, immediately they found some fault. They wanted to decide the matter. And this agreed to consider the case came on 13/2/2019 by the Supreme Court. So Justice D.Y. Chandrachud stated that the court was taking cognizance of the fact that petitioner is aged 108 years and the High Court did not take up the matter on the merits. That too, the petitioner or the appellant is from rural area and the advocate might not be able to meet him after dismissal of the case in 2015. So normally they called for the counter from the other side and posted it after 8 weeks. But now his granddaughter, she has been awarded as the legal heir, but whatever it is, so this is the problem. This man has fought for the case till the attainment age of 108 years, but in the Supreme Court it did not come. Of course, let us hope the judgment will come within 1 year. So appeal will come within at least there may be solace to the family. Of course, the result may be on any side. We can't say that. But anyway, the High Court, in the view of Justice D.Y. Chandrachud, I think High Court has not taken up the matter on merits. So definitely success may come to the deceased sopan narsing Gaekwad. Let us hope. So this is a classic case of CPC where delay occurs. Now, whom we have to blame? Tell me. Because delay is on the part of the deceased, delay is on the part of the High Court, Bombay High Court, Maharashtra High Court for about 27 years for disposing an appeal. Right? So this is the actual factual background. Factual facts are like this. So before proceeding CPC, you see this case and you can appreciate the delay. Otherwise, normally as youngsters, we will be under the impression that the case has to be decided within years. But here, not years, 53 years. Right? Okay, I will stop with this. Thank you very much.